Thank you all for coming. I am Chas Vincent, Senator for District 1, which encompasses all of Lincoln County. There's still a couple of seats up here, guys, if you're looking for a spot. Representative Mike Huff is also here tonight, and unfortunately, Representative Jared Bennett will not be able to make it. There is somewhere, where's Colleen? Oh, right there.
I think I got pretty much it.
Okay, anticipating that probably some of the question and answer of this is gonna run a little while. I wanted to make sure that anybody who had to leave early, there is a clipboard up here. Come and grab it. You can put your name and your email on it, and I will make sure that I get you the same information that I gave out to every legislator in Helena prior to introduction of Senate Bill 262. So you'll have a plethora of information that you can digest. It's a lot of questions that we'll probably hear tonight, but it'll be boiled down in a manner in which you can hopefully understand some of the legal jurisprudence and some of the things that are central to this negotiation. So please talk to Colleen if you need to get out of here and still haven't had a chance to get your questions answered. I'd like to start tonight. First of all, can you all hear me in the back? All right, I don't have a microphone. We're good? All right. I'd like to start with a little travel back through time and go all the way back to 1972. 1972, as you all know, hopefully, that we had a rewrite of our Constitution here in Montana. And at the time, the crafters of the Constitution believed that the DNRC now, was the proper entity to be adjudicating all pre-1973 water rights in the state. And they believed that they could also handle all of the filing and the applications for either a new water right or an augmentation of an existing water right going forward. And for the next 5 years, the DNR attempted to do that. After 5 years of working on the Powder River Basin, they hadn't even gotten one basin accomplished. Not even one finished, and they didn't know when the end in sight was even going to begin for that, but there was 84 basins that they needed to be taken care of, and they came back to the legislature and said this just isn't going to work. About the same time, it was actually about 78, 79, in the end of 78, as we were talking about how we were going to require everybody to get their claims filed, which actually happened in 1981, was extended to 1982, the tribes started filing their water rights, their reserved water rights, in federal court. Now, under the McCarran Amendment, a state, if they have a water court, has the ability to adjudicate their own water rights. Federal, any type of water right, for that matter, can be done in a state adjudicatory court, as long as they have the capacity to do it. There is some exemptions in there where the feds will take over, and we'll talk about why that's important here in a little while. But in 1979, the legislature got together and they said, you know what we need our own water court, and we also need a reserved water right compact commission, because there's a lot of these federal reserved rights, whether they're just pure federal rights that are reserved for federal lands, or if they're for tribes, or if they're for any other federal interest that there may be, we need to try to negotiate those rights rather than adjudicate them, because that process is going to take a long time and it's going to cost a lot of money. So that got started in 1979. Now through the 80s, it was funded off, and it was funded, halfway. It was funded fully, depending on what the budget process was looking like. So it was really haphazard, and there wasn't a whole lot done during the 80s. In the 90s, the 1993 legislature decided, you know what, we're really not getting anything going here. We're going to throw a chunk of money at them. We're also going to reopen the filing ability for everybody in the state, and we're going to make it by July 1st, 1996. Everybody got another chance to file. There's about 4,500 people that came in and filed again. They were junior to the 81 and 82 rights. But you can see that as late as 1996, we were not that far into this game. So if you fast forward now, we can talk about the adjudicative process as much depth as you would like, but I needed to tell you that to understand why what we're doing right now is so important, because this is really a back to the future moment. We're going all the way back to 1979, and we're trying to determine whether or not We should adjudicate or we should settle these federal reserve rights. And there's a clear choice here. Now, the CSKT Compact that is represented in Senate Bill 262 is what I believe is the better choice. And that's what I want to talk to you about tonight, and I want to talk to you about why I believe it's the better choice, particularly for anybody that's here. And I know there's some people that aren't even here from Lincoln County that are in Northwest Montana, and you're affected as well. And thank you for coming. But it affects pretty much everything from the Idaho border to Townsend, all right? Now, we have a lot of, there's been a lot of talk and a lot of chatter about how the off-reservation portion of this got started with Lincoln County, or how we got to where we're at right now in this current compact. So I want to give you a little bit of backdrop on that as well. And it actually started with Commissioner, who was it? It was Burdette that called me up, and I believe he called you up as well, and said, you know what, we just heard that Lincoln County is going to be included in an off-reservation settlement with the CSKT. And we haven't got a chance to look at it, we don't know what it looks like or what it means, but we thought maybe you ought to be interested, and we all agreed. And we said, why don't we get him to drive up to Libby and we can sit down and talk about it. And I asked Chris Tweeten, who is the chairman of the Reserve Water Rights Compact Commission, to send me a copy of what the draft was. So we got a hold of the draft, and in the draft, it was pretty unsettling because of what was being offered up. And I think I can speak for Mike when I say that we were a little bit upset because we hadn't been contacted, we hadn't been talked to by anybody, nobody. The county commissioners, elected representatives, city councils, mayors, none of us have been. And that's really, really frustrating when you consider the fact that some of these in-stream rights that they were considering at the time were actually the main arteries of a lot of our municipalities. Bryan Creek, Libby Creek, Tobacco River, Graves Creek, but they were also all over the place. You had Pike Creek, Yak, Fisher River, I can't remember how many total there was, like 70 total, 72 I believe. And so we got together and we said, you know what, this isn't going to work. So we all climbed in our rigs and we went to Polson for one of the meetings. And after the meeting, we all went and had breakfast or lunch, whatever it was, and got the chairman and some of the members representing the state negotiating team. And we said, we don't like this deal. And they said, well, what would you want to do? I said, well, I would like to get together with some folks and let's see what we can come up with. Would you be willing to consider something else? And they said, well, we got to check with the tribe and see, but yeah, probably. And shortly after that, Mike and I drove over just by ourselves, and we drove over and met with the tribal legal team and asked them the same question. Would you guys be willing to do that? And they said yes. So then we came back and we met with some interested citizens from the north end of the county. We had Steve Curtis and Steve is here, from Glen Lake Irrigation District, and some folks from, I believe, his district, but others that represented the Lincoln County Natural Resource Council. They got together and with a hydrologist from Kalispell and came up with an offer. And I reviewed the offer, Mike reviewed the offer, Jerry looked at it, and he said, you know what, this looks like a pretty good deal. It was Big Creek, Sutton Creek, Boulder Creek, and Steep Creek. 4 streams in the entire county that won't impact anybody. The point of diversions and the effectiveness of that, the use of that water right, which is really just to preclude somebody else from using that water at some point in the future. It does not affect existing uses at all. All right. So from 72 to 4, time immemorial rights, but they don't impact any existing use in the county. That's what was offered to the Compact Commission, which was then offered to the tribe. The tribe agreed to it in early January of 2013, and then we got submitted a compact that had our provision in there, which was a very good deal, which is still a really good deal. But there were some folks that were pretty upset, still are upset, and particularly back in 2013, when I didn't really have any idea to tell whether or not they should be or shouldn't be, because it was a big document. I didn't have a chance to digest it. We all determined that we needed to get some time between this and hopefully next session. So Senator Verdell Jackson and I worked on a resolution in Senate Natural Resources. We passed the resolution out. What that resolution asked for was a study of the compact. And we pushed out the filing deadlines, which is what, when you hear that the tribes are going to file their deadlines, because it's a statutory requirement. They either file by a certain date or they don't get the ability to pursue their water rights. And that's June, and it actually expired in 2013. They have a 2-year, there's a 2-year period in there they have to file within. It expires on June 30th of this year, 2015. The governor, and we also put a study in it with some resources because we wanted to take a look at what was in this compact, particularly the water modeling that was used, that was primarily built with tribal resources. So that bill was vetoed though. And when we got into the interim, I climbed onto the Water Policy Interim Committee and got elected chair of that committee and convinced a majority of the members that we ought to take the entire interim and study the water compact. We didn't have a whole lot of resources, but we were successful in getting a third-party objective, which is everybody considers a third-party objective reviewer of hydrologic information, hydrogeologic information. That is the Bureau of Mines and Geology. They've worked with us on a lot of different things. They stepped up and said, we'll take a look at the water model. It's very complicated, it's very big, but we can tell you if it's reasonable or not. If it's there's some tests that we can do on the assumptions, because a water model is really a law of averages, but we can tell if whether or not this model is reasonable. And they had 10 different technical committees in conjunction with the Water Policy Interim Committee. Came back, provided us a very extensive analysis on that water model, and essentially what they said was, yes, the amounts of water that we're talking about is probably going to be sufficient, but we can't tell you if it's accurate down to the ground on the different places in each of the different basins, because really nobody can. That's how the model can be used for. So the committee got together after reviewing and digesting. We looked at the off-reservation, we got some legal analysis, we heard hours and hours and hours of public testimony during the interim. Had a lot of folks show up and provide some really good ideas for things to look at, which we did look at. There were some things that we could not do that were requested, like conduct an environmental impact statement. The committee does not have the ability nor the resources to do something like that. But we did get a lot of the answers, and in the meantime, I continued, besides being the chairman of that committee, I continued my own personal study. We made 11 recommendations to the Compact Commission at the completion of the interim and adjourned in October. We actually pushed it off for an extra month so we could get those questions into them. We were waiting for an economic analysis that was supposedly coming that never ever materialized. But Compact Commission got our recommendations and said, we'll see what we can do. Thanks for your time and effort. And really that was the last I got to see of any of the changes or anything that was, as the negotiations continued. I really wasn't privy to whether or not all of those things were in it or not. I did not know until, in fact, January 7th when they finally made a vote, which was unanimous on the Reserve Water Rights Compact Commission to send it to the legislature, if, in fact, all of the changes were in it. That's why it took me until about January 20th or 21st before I had the time to thoroughly review it and make sure that all the things that I wanted to see in it were in it. And after I found out that they all were, I agreed to sponsor the legislation. Now, there's a couple of different ways that I can go from here. I don't want to lose anybody in droning on and on about the compact because it is big, it is complex, it has lots of different facets to it. There are a lot of different things that long history, case law, a lot of jurisprudence to consider. But what I will say before I open it up for questions is that there are really fundamentally 3 different things that we can all argue about until we're blue in the face, would really result to what I would call a risk assessment, all right? There is no specific case law for this compact for off-reservation in-stream flows. No specific case law. What there is, though, is other Stevens treaties that do have case law, and it's a pretty good roadmap for how we could expect the process to proceed if we decide that we did not want to settle off reservation rights and we wanted to adjudicate and litigate them, all right? So that's one thing, that's a trip to the Supreme Court that we may or may not get. I doubt we even get granted certiorari on it, but that's one of the places that we can all agree or to disagree on. And as far as I'm concerned, and as far as the Attorney General is concerned, and as far as the most conservative lawyers that I can stick myself in a room with over the last 2 years, there's a better than 50% chance that they're going to be successful. All right. Second is whether or not the Reorganization Act of 1934, when the CSKT was the first to actually get into that and sign that, whether or not that diminished the tribe, right? Whether or not that diminished the ability for them to claim all of the water on the reservation for the purposes of satisfying the needs of that reservation. Now, I would say that it's been settled once by name in a Montana Supreme Court decision. Could it be appealed? It could be tried. Nobody's, as far as I know, nobody's tried to appeal that decision. I think that it's unlikely, and so does, again, the Attorney General and a lot of those other lawyers that I've been working with that are conservative in nature. They don't believe that it would be overturned either. But there is that chance, and I want everybody to know that. That is a legitimate argument to make. And the third, it has to do with the biological opinion on the bull trout for some of the on-reservation area years. Right now, we have a 1987 Ninth Circuit decision that basically says that there is time immemorial in-stream flows on the reservation. There is also 1855 rights on the reservation that were established when they signed the treaty. And we also have the feds, the U.S. Fish and Wildlife, that want to make sure that there's adequate in-stream flow for the bull trout. So they have basically agreed to hold off on the implementation of that because this is a Federal Reserve right. They have the ability to do this, but they're negotiating in good faith with the tribe, and they're going to allow the tribe to do, and they have agreed with the terms inside of this compact because of some of the things that we're doing with the resources for habitat, and because we're trying to put more in-stream flows than there have been since 1987 and 1996 through efficiencies, that will be sufficient, which is a big deal. Now, there is a case that we can also pursue all the way to the United States Supreme Court. All right? We could argue that the biological opinion for the bull trout has, they cannot add water on top of the in-stream flows that's already there because we're going to be adjudicating this and they can't do that while we're adjudicating these rights. That is an argument that could be made without a compact. All right? How that goes, who knows? I'm of the belief that we don't want to find out. I really don't want to go pursue for 20, 25 years, spend hundreds of millions of dollars to go get the answers. I'd rather settle. And that's what I want to talk to you guys about, is what are those costs, who's going to bear those costs, and more importantly, what it really means on the ground, not only here in Northwest Montana, but also on the fields of those irrigators who are trying to stay in business. So with that, I'd like to open it up for questions, and you'll have to forgive me. Some of the answers may be a little bit long because there's a lot to talk about, and there's not a lot of yes or no answers to all of these questions.
Oh, Chad, we know that the tribe has bought her dam, and so looking at the reservation on a map, it only covers a small portion of Flathead Lake, but they're guaranteed the top 10 feet of that lake for their dam purposes. But if they can't use it for power, they've got to spill it. So how does this all come into the compact?
Well, the compact has absolutely nothing to do with Kerr Dam.
It doesn't.
It has absolutely nothing to do with it. Nothing that is going to happen with the level of the lake due to the FERC licensing of Kerr Dam has anything to do with this compact. Where the compact does have something to do with Flathead Lake, however, is that it establishes a low pool level of 2883. Okay? So that pool will not get any lower than that for any reason, for power generation or otherwise. That water is reserved at that level. It will not get any lower. And there's a lot of folks that were concerned about, what's going to happen for recreation and a lot of the guys that have businesses along the shores of the lake. And this compact does not do anything with that besides establish a minimum pool level. which would, it will not go below 2883.
Thank you.
Yes, you laid out all the steps whereby you talked to all these different organizations, these different people to develop this compact. Can you explain why you didn't follow Montana law on these procedures? MCA 85-1-101 stipulates step by step that you must use coordination with the local government, which is the counties and the cities, and the state and the feds. And every time the counties, cities wanted to get involved, they were shut out. And according to state law, they must be included. There's no alternative to it. Why wasn't the law followed?
First of all, Jim, I wasn't the one negotiating. I was the one who was providing recommendations to the negotiating team, which is made up of Montana representatives, it's made up of tribal representatives, and it's made up of federal representatives. In the terms of the compact, this is a settlement. And under a settlement, there is no requirement to do anything but do what they're charged to do, and that's to settle the reserved water rights that they were charged to settle. Now, if you think that there was a violation of law because they're settling it, the fact that it has to be, that settlement has to then be ratified by the legislature, by the tribe, and by the federal government. And some compacts can actually be ratified without Congress if there's no appropriation in it. If there's an appropriation in it, it has to be ratified. It can be ratified by the Department of Interior, like somehow.
If I use the word settlement, I'm sorry, that was an error. The Montana Code Annotated says anytime there is a water agreement, here is how you proceed to negotiate that water agreement. And it's very specific about it. It says you will get the local government, the state government, the tribe, the federal government, whatever, and through the process of coordination, where each party gets to stipulate their own procedures and coordination, through the process of coordination, that's how you will develop the 1,400-page document. So why wasn't the state law followed?
Well, Jim, I need to look at the statute that you're citing, but I can assure you that if this Reserve Water Rights Compact Commission they've done this 17 times previously, I would imagine that somebody would have made the charge that they were breaking the law when they were ratifying these compacts like we have at the state, federal, and tribal level. But I'm just telling you that it's a Reserve Water Right Compact Commission with the sole intent of settling, not adjudicating, not litigating, but settling these rights that have to be ratified by the state, by the tribe, and by the federal government. And there's due process that is involved with it. They have public meetings. They've done all the due process things that are required. Okay, well, I guess...
They didn't do the due process that's required by the state law.
Well, Jim, then I guess you got the lawsuit to take it down.
I guess as our state senator, I expected you guys to be aware of the law, at least research it and find out what the law states about.
And I'm telling you that you were mistaken.
I'm mistaken, okay.
Senator Vincent, Representative Cuff, thank you guys for having this meeting. This is an awesome opportunity for it, and I really appreciate it. And for the record, I'm Derek Skees, and I live in the Flathead, but this affects my county as much as it does yours, so I definitely thank you for giving me a voice here. You kind of somewhat answered the first question I had is, you said in the introduction that you started to negotiate with the tribe. My first question is, where did you derive the legal authority to do that as a senator when the only legal authority to negotiate with the tribe was given to the Water Compact Commission in '79? And then the second part of that question, because I think you just tried to answer it here, is who negotiated between, you said from October to January when you got out of the involvement, the Water Compact Commission then took over. Who negotiated from that point on, or from the point previous? So once you gave the recommendations to this negotiating team you just talked about, who was that negotiating team? Because I talked to the Attorney General, and they said they were the ones that negotiated this. Where did they get the legal authority to do this? Only the CSKT and the Water Compact Commission, by Montana law, in '79 has the legal authority to do this. So how did all this negotiating take place?
Well, the Reserve Water Rights Compact Commission were the ones who did the negotiating. We had members, we had representatives of the Tim Fox Attorney General office that were participating with the negotiating team, recommending things that we believed that, you know, and I was working with them as well as far as providing my input on what I believe that the state's negotiating team ought to be doing and ought to be working towards. Now, I did not negotiate in any formal way whatsoever with the tribe, ever. I did drive over there one time with Representative Cuff, and we asked them questions about why they were, what are these provisions in here? Why do you want this? Was really the question. What makes you want to have water rights in the main arteries of our municipalities, which are already, in a lot of cases, almost over appropriated? Why would you want that? But there was no negotiation. There was a question of, would you be willing to consider a counter, another offer if the state offered you something else? So then, as soon as they said, well, yeah, we consider anything. The negotiation isn't final. We then went back and met with some of the folks locally here, who then met with the state representatives who were on the team, and they offered it to the tribe. So there was, the part of, as far as who was negotiating, everything was legally followed as far as the process. Where the information came from, it came from a lot of different places, as it should in any process. If people are going to be truly open and say, we want to take your input, what do you think, provide public comment, we better hope that they take that public comment, and they hope that they take that interest. And when it comes from a state senator or a state representative who are of not exactly freshmen, the likelihood that they probably ought to have their ears open to say that, the legislature has to ratify this. So, we're thinking that the legislature wants some fingerprints on this, and they want some things corrected. And we corrected a lot of things. I figured that was going to be your first question, because you've read the 2013 compact, right?
Yes, sir.
And you've read the
There's very little difference.
Okay. Very little difference.
The first thing that Tweeden and the tribe both said when they came back after you guys defeated it in 2013, Tweeden said, we are not going to substantially alter anything in this compact. And the tribe said, we are not going to substantially alter anything.
Absolutely. That's what they said as soon as it was defeated in 2013.
So if these guys are the ones that were negotiating, not you guys, then why did that change up until October?
Well, I can tell you the first thing that changed as far as substantively, and it was when we asked the Bureau of Mines and Geology to take this water model. And this is what the tribe did from 1983 to 2003. They were collecting baseline data, spent millions of dollars collecting this data, which they then hired HKM out of Billings to make a water model, so that they could use that to determine who was getting what water, where was it going, how do we negotiate for the terms of in-stream flow, and at that time they were talking about farm allotments and how many acre feet, or 1.4 acre foot allotments, and they came up with this water use agreement through negotiating with the Flathead Joint Board of Control, and we wanted to know, was that even reasonable? I mean, the state had no involvement in it. We had to take a look at it. And as soon as we got the Bureau on it, and the state looked at it with the Bureau, because the state wasn't involved in that. That was the Flathead Joint Board of Control doing that negotiation, and they negotiated themselves into a corner. Absolutely. That compact, it was a good reason that compact didn't pass last session. That those irrigators, that area is 40% efficient already. Part of it because of everything being worn down and lack of efficiencies.
But from poor management by the tribe.
But some of it poor management. But there's no way. I mean, I'm just telling you, with the way it was laid out, it would not have worked. So the first thing, and I don't see how you can say that's not substantive. The water use agreement was thrown out. Now, you're exactly right. At the very beginning, after 2013, yes, Mr. Tweeden was sitting here like this, and so was the tribe, because we're done. But as soon as somebody else looked at that and recognized that it was, and we were going to be talking about it in an interim committee, suddenly some arms became uncrossed. All right. So to say that we directly negotiated, no, but just by studying it and looking at it, things began to move. And that's a substantive change. What is now in the compact, we replaced that with adaptive management provisions. And even though the Bureau of Mines and Geology came back and said, you know what, this water model, the amount of water that we're talking about diverting, it's going to be adequate with the efficiencies, but we don't know, we wish we would have spent time looking at the projects rather than looking at the model. And so we said, well, how do we engage in this discussion? Now, before we made the recommendations to the Water Policy Committee, I was also talking with members from the Attorney General office saying, you know what, they're saying that this isn't working. You need to be talking to that negotiating team and coming up with something that's gonna make sure that those irrigators get their historic consumptive use on their ground. They need wet water. You need to make a way to make that happen. This water model is a good tool, but that, with anything with the law of averages, you're gonna be right on right here, and you're gonna be a smidgen off over here, and probably way off over here. So what we did with this compact, we put in adaptive management provisions. Based upon historic consumptive use.
No, based upon in-stream flows.
No, based upon historic consumptive use.
No, that's what the tribe based on with in-stream flows. When you do a model, you look at what you want to achieve with that model, and they backtrack to achieve that. They want in-stream flows. They don't want historical use of irrigators. And that's why the model was flawed, and it still is.
We can disagree. You need to read the report from the Bureau of Mines and Geology because that is not accurate. The hydros model that was used, it was used to determine whether or not there was sufficient water to satisfy historic consumptive use.
All right, can I have a follow-up?
So, well, let me finish. What we put into the compact after that water use agreement was out was just that. You have adaptive management provisions inside of the compact that is going to make sure that we're going to make river diversion allowances. We're not going to do this Neapolitan ice cream stuff that they were doing, which was you get a standard farmer turnout allowance, and then we got a minimum enforceable flow, and then you got a full farmer turnout allowance, and then you've got a target in-stream flow, and then after that, if there's any water left over, we can all share what's left. The way it was designed, there would have been nothing to share what is left because there would have been nothing. So we tossed that out and went back to river diversion allowances, and we said, we're going to divert enough water to provide historic consumptive use on these fields. And if there isn't enough water, that's what we're spending the first $4 million measuring in this compact, is making sure that they're measuring and making sure that they're getting their historic consumptive use. And if there isn't enough water, we're going to go take a headboard out and get that water down that ditch so that guy gets his historic consumptive use. We put adaptive management provisions in there to allow them to change on a monthly basis if they want to. The project operator can change those allowances. That was crucial to me. And the other thing that we put in there, which I really objected to in the previous compact, was the fact that no one, if you entered into this, I considered it to be a takings. I considered it to be something that was a takings of those individuals because it made them dismiss their claims. It made them dismiss their co-ownership of the water. This compact, you can get your delivery right, which is your historic consumptive use, and we will spend millions of dollars making sure that you get it, or you can adjudicate your claims.
That's not true.
And you can actually do this and this. You can get your historic delivery right, and you can adjudicate for your co-ownership of your claims.
Delivery right is a new claim put in the compact from this cycle. Delivery right is not a right to water. It's a right to have it delivered to you. It's entirely different than a right to water. But we're getting lost. Can I have a comment?
No, I'm not getting lost, sir. You're interrupting me, so let me continue.
Please.
What I'm saying is that you are going to get your historic consumptive use. Okay. And you also get the ability to adjudicate, which is what you want to do. You want to adjudicate those rights. If you don't want a compact, you want to go adjudicate. That's all that there's left. That's what we have to do, is adjudicate. And what I've done with this revision, what I'm sponsoring in this revision, is that you get your delivery right and you get to adjudicate if you want to. You get to have your cake and eat it too.
So who do you adjudicate? Who is the person that's in charge of adjudicating? Tell us the membership of that group. So if I'm the farmer and I don't like my delivery right because it doesn't mean I get water, it just means you can give it to me. It doesn't mean I get it, it means I can get it delivered to me. Who do I go to complain about that? Do I go to the state of Montana or do I go to the tribe?
Who do you go to complain about whether or not you're getting your water?
So you're saying that I have the ability to argue my point and get that changed. Who do we argue that to?
No, what I'm saying, Representative Skis, is that you are going to have your delivery right that is going to come from your district. The districts are going to get amount of water that the project operators are going to be divvying up, and you're going to have that delivery right, that amount, that historic use amount that's going to stay with that land and travel with that land. The only way that you could actually lose it is if the district itself took it from you. Nobody is going to take it from you. the only way it would be taken is if the district took it from you because you failed to make your assessment fees. You haven't paid your assessment fees, you haven't paid what you have to pay to the district, okay? So that's just like, and actually, it's not just like any other irrigation project in the state, because there's no one else in the state that actually has a delivery right to federally appropriated irrigation project water.
Because it didn't exist until this compact.
This delivery right is something that is absolutely, and thank goodness it is, because we're guaranteeing, the feds for the first time are guaranteeing that water, all right? Now, on the other side of this coin, what I'm saying is if you have your claims filed in 1981 or 1982, and you want to go adjudicate, you want to go litigate for co-ownership of that water, you believe that you're entitled to even more water than your historic consumptive use. You believe that you, even though you haven't put it to historic consumptive use, because that's what you have to prove in water court if you're going to go into a water court and object or get anything resolved, you have to show your historic consumptive use. If you think you're entitled to more than that, if you believe that you're entitled to more of it because the Ninth Circuit Court in 1987 took that water from you and they said that it was time immemorial and it needed to remain in stream, you could do that with this compact. You can still go adjudicate for the co-ownership of that water. That's why I say, we're not taking anything from you, but the delivery right, the reason it is so important is because I also think that we ought to get in front of the biological opinion on the bull trout. Because if we do not, that is what's going to get us next. Because the feds are not going to wait. So you get your delivery right, and you get the ability to adjudicate. And I do not see why it is good for Lincoln County, why it's good for anybody who lives in the 35 or 40 other basins that have already been adjudicated, that are waiting final decree. We're going to be done with adjudication by 2028. 2028, we're going to be done. If this compact doesn't pass or get ratified, it's going to be decades. Because we're going to reopen 35 of these basins. Because these claims are going to be treated as prima facie claims. They have the same standing as everybody did in 1981. The only difference is that these federal rights, because they're tribal reserve rights, the lack of diversion, the fact that they haven't put that water to beneficial use, are not grounds to dismiss those claims. So the only way that when we have all these claims filed all over in Lincoln County, the only way that we're going to win is if we can prove that they were not here in 1850.
That's not true. Prima facie rights only exist on the federal reservation. They do not exist off reservations. If you look at Snake River, they did the same thing. They brought out the big stick and they said, if you guys don't do this, we're going to file thousands of water claims. How many did they claim? 6,000. How many did they win? 5. The rest were thrown out. And the 5 that were won on federal lands. None of them were won on state lands. So the prima facie only occurs on the reservation.
That is not correct. What is the rest of the story, though? The rest
Wait,
of that,
are you saying prima
story.
facie is off reservation?
Yes, absolutely.
Could you email me where you get that?
Absolutely. I'll have the Attorney General send it to you. He wrote it up. Well, you can believe, I'm just saying, you can sit here and argue until we're blue in the face. How about the guy who is going to be doing all of the negotiating for us? Because when this compact doesn't pass, it's going to be just like Idaho. And the other side of that story, when they only got 5, I keep hearing it, well, they only got 5, well, what is the rest of the story? Does anybody want to know the rest of the story? I did. So I drove over there and talked to some of them. You know what the rest of the story is? 20 years of litigation because they put 3 judges together on a panel that agreed that they did not have off-reservation claims. They did not have that prima facie standing. So they appealed. Attorney General of Idaho, just like it will be the Attorney General of Montana, reads the briefs, gets his team together and says, you know what, this is not going to end well. We need to settle this rather than go through with the litigation because they're going to get time immemorial rights or their treaty right dates in Idaho. So they went back to the tribe and they negotiated. 200 off-reservation in-stream flows is what they gave. 200.
Because
They gave them 2 entire fisheries. They gave them over $40 million, and they gave them over 50,000 acres of land. That was the end negotiation in that.
Because their Attorney General folded, didn't fight.
Okay.
That's only half that picture.
So, when you're talking to those individuals about whether or not they thought that it was good to negotiate or not. They felt that they got a better deal by negotiating than they would have by litigating. They were also looking at what just happened in Washington, in the Washington Supreme Court for the Yakima tribe, who determined that even though they were diminished, they still gave them in-stream flow rights. Go talk to the farmers and irrigators down there that are done. They're not kind of got water, they got no water. They're done. That is the case law that you have to consider, and that's the risk analysis that you have to make. Do we want to go answer these questions, and what would be the final outcome? We know where they want to get the water.
But you just said there was only a 50% chance that we would lose.
I said it's better than 50% chance.
Oh. So therefore, because of the fear of that, we shouldn't fight it?
What is the benefit? When every person, like, let's just take Lincoln County for example. Big Creek, Steep Creek, Boulder Creek, Sutton Creek. We got 4. And we got the time memorial right that is linked to the FERC license for the Libby Dam. All right? Doesn't impact anybody. We have that option, or we have everybody that has a commercial well, a domestic well, a municipal well, an irrigation well, has to go get, if you're incorporated, you have to hire an attorney. Have to, just to object. If you want to represent yourself, you can do that as long as you're not an LLC. And you're going to go into water court because they have prima facie standing, because I spent a lot of time with the water court judge talking about this very issue.
On reservation, yes.
Off reservation.
That's not true.
Well, you can say it's not true all you want. I'm telling you that it is.
And
So
you can obviously say it is as much as you want.
Well, what case law do you say that proves otherwise? Is I guess my question.
Let's go down another path. I've been dealing with this since 2011. From 2011 to 2013, I was at every single one of the Water Compact Commission hearings. I got to hear the tribe, I got to hear tweeting. The state never ruled or worked in our favor. They were always on the tribe's favor. And then you tell us today that the water model was based on a third party. That third party was a state agency. How can you tell us that the water model was beneficial to us, the average water user in Montana, when the state has demonstrated time and again that they are on the tribe's side on this issue? How is that a third party assessment?
The third party that looked at it was the Bureau of Mines and Geology. The state did not create its water model. The tribe did. The tribe paid for it. The tribe used it in the negotiations.
Is the Bureau part of the state?
The Bureau of Mines and Geology is the Bureau of Mines and Geology.
It's a state administration.
And it's a state.
Well, and you can choose to not believe their credibility as well. That's fine.
I sat in the room with these people so many times. We begged them to look at the Stevens Treaty that actually had a primary date before Hellgate. Refused it 3 individual times. These people, all they ever did was take our objections and find a way to talk about it with legalese, to battle us on the front end, and they did nothing to address our concerns. These people have demonstrated for 2 years that they're not to be trusted. Why do you trust them?
If I can continue to talk, I'll tell you about what's in the compact. I've read it. I know what's in the compact. I know what isn't in the compact. And we can laugh and snicker and whatever. That's fine. I came here to answer questions from my constituents, to try to get them answers to questions they have. We can talk anytime you want, Derek. Okay? And I'll provide you all the information that you want that justifies my position. As long as you promise to read it.
Then I will ask one more question.
Okay.
I'm a constituent, Mr. Benson, and I heard LCNRC mentioned, and that you had worked with these different negotiators to help alleviate Lincoln County from impact from this. And as I am chairman of LCNRC, this is rather news to me. That's one. I have an email from you that states that through the negotiations that you had done with Steve, and I first time I'm hearing LCNRC, and such that you have these people collectively help to negotiate some of these impacts away, and yet you claim you were not a negotiator. So I find that confusing. That's one question. I find that confusing. That I have an email just meant that states that you did negotiate, and then you're not a negotiator. That's one
believe there were members of the committee that you chaired that were participating in the discussions. And Mr. Curtis is sitting over there. He could answer the question better than I could. I know that there were members that from Lib Irrigation District, because Mr. Curtis was there. There were also members that I believe I thought that's what they said they were. Maybe I was incorrect. But what I was doing was I was trying to participate with the only irrigation district that we have in the county, because the rights that would be filed, those prima facie claims, are going to be filed right in their backyard. And the only way, again, that you're going to be able to prove that they don't have the rights is to prove that they weren't there. They call it the Tobacco River, for crying out loud. And all that they're going to do is stand there with their map from the Smithsonian, and how are you going to win?
In the assignment of the, I don't even know where to start here.
Okay, well,
Okay,
is there any other
the
questions?
question that
Yeah, I had a
have for
question.
you
How about
is, the other
somebody
half,
from the
other half
community
of
here
the-
ask a question? This is getting ridiculous. You guys have been fighting this for God knows how long. Why is Lincoln County giving water to the tribe? There's no reservation on this county.
Article 3 of the Stevens Treaty.
What is the Stevens Treaty?
The Stevens Treaty it's one of 7, actually, is what the CSKT is based on the Hellgate Treaty of 1855, all right? We're one of 7 in the Pacific Northwest in the Columbia Basin. Article 3 of that is different than the other treaties that were signed with other tribes. And it's the way that that treaty is interpreted, could be interpreted, is going to be interpreted, I feel, that is the reason that we need to negotiate rather than litigate those claims. The process of adjudication in the state, the way the process works, is that these claims can be filed, right? Because we've asked them to the negotiating table since 1979 to keep them from making those claim filings. We've asked them to come negotiate with us. So it's not a threat from the tribe. It's something that we make them do if they want to claim rights that they feel are federally reserved for them. So when they make those claims, they're going to have state-based standing, but it's even worse than that as far as from an objector standpoint, because lack of diversion, non-use, it being in stream, is not grounds to have those claims dismissed. So everybody, regardless of whether or not the claim is going to be successful, you're going to have to object to it. And it's not just irrigation. It's domestic, commercial, municipal. Everybody will have to get back into the adjudicative court to object to the claims, and then hope and pray that they're successful and they get some. And do I think that they would get all of them? No, I don't. I think that realistically, there's 2 places in the state, though, that are going to suffer the worst through adjudication. It's going to be the Bitterroot, and it's going to be right here.
Explain to me why Lincoln County is going to lose water rights. I have water rights I filed for 30 years ago, 40 years ago. Why would I be affected by this?
You are not going to be affected by this compact if it is ratified.
Unless he puts some more water wells there.
It will affect no water right existing in this county. How about future?
Chaz, would you explain how Article 3, which I have right here, and it says the exclusive right of taking fish in all the streams, running through or bordering said reservation, and it goes on in the usual places
Accustomed
in common
places,
with,
yeah.
It doesn't say anything about water. Water isn't mentioned in the compact. The other thing that we really need to understand is that they ceded and conveyed to the United States all their right, title, and interest in and to the country occupied. They gave it all up when the reservation was created.
I would encourage you to read Winter's decision, Winnin's decision, Greeley, Adair, Flood Edge Water Control, and in the 1987 case. If you read those cases, what you're talking about, Winnin's was Winnin's is the case law for off-reservation Stevens Treaty rights. Have you read Winans? You shook your head like you did, I'm just curious if you did.
I probably have in my
Okay,
stack of
well,
documents at home.
if you read Winans, if you start with Winans, you can see how it is construed. Winters talks about the fact that these treaties are supposed to be implemented in a way that was how they believed, from what they believed they were getting when they signed it. Now, the same question, you're having the same questions that I did when I first jumped into this. And believe me, I understand where you're at. I understand how on earth, because that was my initial, how on earth could we be talking about water rights in Lincoln County? That was what the Treaty of 1855 was you're down here and this is open, and of course then the reservation was opened up in 1904 by the federal government and then closed again in 1934. But when you have to study the case law to understand how these treaties have been interpreted. And when you look at the case law and what has happened to the people on the ground, you can disagree with it. I disagree with a lot of it. But that does not change the fact that you're not going to get wet water on a field somewhere, because they want to keep their water in stream, non-consumptive use. And they've already got in-stream flows on reservation. They are going to file off reservation. Will they get all of it? No, they're not going to get all of it. Well, why should we even risk one water user in Lincoln County if we can agree on 4 streams that impacts nobody?
So you're asking us to let our neighbors hang? You're asking us to accept this and to say sorry, but to say screw everybody else? Is this
No.
what you bring before us? Because I don't think that's really a Christian way to look at it, Chaz.
Oh, American.
It's not how I was brought up.
The reason that, if I was going to do that, and that was what I wanted to do, I would have supported the 2013 compact. The reason that I led the charge against the 2013 compact, because I was afraid of the other provisions that I felt would be detrimental to the other people in the state.
And yet, when you opposed the 2013, and it didn't pass, in front of the Senate Judiciary Committee hearing, you stated that your primary reason for having did not support that version of the compact was about threefold. One, that it was thrown into the legislator's lap too late to really digest it and understand, and there were things in there that were of concern to you, that you thought ought to be amended, and therefore you voted against this. So take a look at the 2000, I want you to answer me what the difference is. In 2015, this compact wasn't delivered to the legislators in final form until just the start of the session. There wasn't and isn't and hasn't. I, by the way, will tell you, yes, I have read the compact, I've read all the amendments, I have read all the different case laws that you have mentioned. There wasn't time, there isn't time in this legislature for the legislators to fully comprehend what's in the compact. And yet, you're asking them to pass it without amendment. You're asking them not to do, for the same reason, what you didn't in 2013. You're telling them they cannot amend this. How is this not a hypocritical position?
Because there was thorough legislative involvement in the revisions that are found inside of this compact, this revised compact. First of all, as far as the no amendments concerned, you cannot unilaterally bind 3 parties through an amendment. That's when they created the Reserve Water Rights Compact Commission in 1979. The reason that they put legislators on it, 2 from the House, 2 from the Senate, was so that we had a connection to that committee. They also recognized that it was going to be a straight up or down vote, because that's how settlements are dealt with. There's been no amendment offered on any of the 17. You either support it or you don't. It's a settlement. It's an agreement. They did not expect for it to come back to the legislature and for the legislative process. Otherwise, why even have a compact commission? We have an agreement between the tribes, between the feds, and between the state. They bring it to the legislature. There's some things that I would love to amend into this thing. I would actually love to amend some things out of it, to be honest with you, like some of the money, because I struggle with some of the money in it. But the reason that I can justify even the money is because when I look at the alternative, of what we're gonna be doing, we've got $95 million already into the adjudicative process in the state. We're almost to the end of it.
But
If we go down the other track, we're looking at 70 million. But as far as hypocritical, your question, or it's a statement, I'm not sure. We had the interim process of the Water Policy Interim Committee that had several meetings, over 10 technical meetings, involved in just in direct analysis. If you followed it, you'd see that we've looked at the compact pretty comprehensively. And it's all online, and you can go on there and you can read all the reports from the staff. We had them looking at everything, and some of the things that I wanted to know was just some of the same questions that we're getting tonight. How on earth could we be talking about off-reservation in my backyard?
Well, you didn't answer my question, Chaz. My question didn't involve legislative involvement. Why have a legislature? Why not just...
Part of the reason, okay.
Just a moment. Why the Reserve Compact Commission, why couldn't they just say, yes, we agree on it, let's pass it? No, that's not what happens. It has to go to the Senate, the House, and they have to agree on it. Legislative involvement is not what I was speaking to. It is the knowledge of the individual senators and representatives who will and have to vote on this to pass it. What is their level of knowledge? As you in 2013 admitted you didn't have the knowledge of what the compact contained because you didn't have time. I put to you that the same condition exists today with this compact, that the individual senators and representatives have not, and many of them have stated this. How can we be expected in session to have a 1,400-page bill thrown onto their desk and have any hope of understanding what's in it? This is exactly the situation and the reasons you stated in 2013, and I commend you for that.
Shit, they pass a lot of bills they don't know what a person doesn't know.
Excuse
Thousands
me.
of bills they pass and they don't know every word and understand every word of it. They gotta go by what the commission, and they're committed. They gotta trust their fellow individuals, I think.
And that
Comprehend.
works.
So then, can I talk?
Well, you've been on it, and I want to...
There's a lot of people that have other questions too. that I
The
would like to
question
get to.
I had, Chaz, which you didn't answer, was I feel that this is hypocritical because the position you were in that you stated you could not is identical, Mr. Vincent, to the position you put the individual legislators into. How can you expect them to have knowledge enough to vote yes or no for this compact?
Because we have hours and hours and hours and hours and hours of participation of legislative committee working on the compact. We have hours and hours and hours of presentations about the compact. It's all online. Every legislator has the ability, has had the ability to follow this process. I have given them as much information as I can, as readily available as I can, boiled down into, I'm the reason that these packets were created, that was me, because I wanted to help those legislators for that exact reason. But the issue is that we have legislative fingerprints on this bill because that's what they were doing before they got, the reason we didn't get it until January is because I dumped 10 of them right in their lap in October. I said, here, you need to do these things, otherwise don't bring it to Helena. And they spent a long time negotiating over those things that the Legislative Interim Committee charged them with integrating into the compact. They gave us every single one of the things they said they were going to try. Every single one. The tribe gave all those things. And so it's my job as a legislator who does know it to explain it the best I can to everybody that I can.
And there's an implicit trust me in there. Is that, I don't know,
Okay.
I'm not a rep, but is that the condition that exists, Mike, being as a representative? Do you implicitly trust all others, or do you take a look at a bill and read through and attempt to comprehend for yourself?
Why don't you sit down, Chaz, take a break. Let me talk just a little bit since she asked me. Take a deep break. What I'd like to do is back up to,
Can't hear you.
okay. Excuse me. What I'd like to do is back up a little bit, cover the ground. Chaz covered this very well. Chaz could probably cover this better than most people I could think of, maybe anybody. And going back to 2012, what he said, you know, we did hold a meeting. We met with primarily folks in Eureka. There were a few others and county commissioners. And we did, and we being a group of us, and a couple of us probably really led the flag all the way. And we did bring some changes, and part of the reason, Rhoda, that in 2013, that the final compact did not come up until middle of January, 1st of February, was because we initiated some change right at that time. And if I believe the date was January 17th. And we were asked to go and meet with the tribal attorneys, because we had had the meeting in Eureka. And at that time, the indication was they were going to take those 4 streams off federal
Okay,
lands.
give us the day, give us the date, give us the year,
2013.
2013.
Yeah, and it was right about January 17th, because that's the date that, I think it was my birthday, that's why I say I think it was that day. It may have been a week later, but it was right. And at that time, they said, hey, we're sorry, we're not gonna make that trade. We're gonna stay on Tobacco River, Grave Creek, we're gonna stay on Young Creek. I asked Chaz if he wanted to go down to the meeting with me. Chaz said, hell no. He said, I'm a no vote. I'm not gonna sell out my brothers in the flag. And I went down and met with them, and they said, well, we're gonna relinquish on that. And I basically used a little bit of mill talk. And in a pretty strong way, said, no way, I'm out of it, I'm a no. A week or 2 later, I got a call in the hallway when I got the call. And they said, okay, you won, we're gonna get it all. So that change did not happen until almost this time 2 years ago. Chaz and I and Jerry and Steve and Scott and the commissioners were all a big part of bringing that. And we were saying, we're gonna get Lincoln County in the best position we can. Chaz was a big part of that. Chaz was a big part of holding that position throughout the following negotiation. Jump a little bit forward to when the veto happened. And I happened to have a face-to-face with the governor shortly after the vetoes. And the governor didn't see why there should be another committee involved. We had proposed to have the Water Policy Interim Committee. I told the governor maybe he didn't need it, but we did. The legislature needed it. That's kind of a long ways getting there, but that's where it went to. I told the governor that. He got a funny look on his face like he never thought of that before. I said, maybe you don't need him, but we do. We need somebody that we can trust because we don't trust the compact committee. So, it wasn't too long till the governor reached out to Water Policy Interim Committee, which Chaz was chairing. And Chaz dug into it, the committee dug into it, and I think did a very thorough job. Now, he came to the conclusions he's presented, and I appreciate greatly the work he's done. In the end, you know, I come to a different conclusion. And, you know, and it is not a great scientific conclusion, but it's a basic feeling that it's not right from the very beginning. That I still have trouble with the question over here of relating those initial words of the right to fish in the traditional customary places. And I do understand all the court cases. I don't understand all the court cases, and I can't cite them. Chances, I mean, he is a wizard on this stuff. Some of you are wizards on it. But for me, I went down and I spent a couple of days in an attorney's office going through the case laws back in 2012. Came to much similar kind of information. That maybe whether it's, some guys say we stand 50% losing or better, some say we have a little better chance of winning. And all of the other material, for me, it came down to, and I sat and I pondered hard and heavy. And I wasn't going to make my final decision until it was on my desk. As it came forward, and I told some folks, I'm not gonna make a decision. I owe Chaz the courtesy of listening to the presentation and seeing what the changes are that have come about. And I listened to them, and then I went and I spent a lot of time hard thinking on it. And for me, it basically came up to, back to that fundamental thing, even though all the laws, all the case studies, and maybe I'm very foolish for this. And the big question is, what do we do? What do we do if we don't do it? We go to court, and everybody says, well, we're going to court either way. Well, in the one case, we're going to court at the compact status. It can't get worse than what's in the compact. In the other town, we go back to where every, a lot more water rights individuals have to fight it on their own, and the burden. And, as Shaz has said, are you willing, what are you gonna do when you face all these people and there's millions of dollars that are gonna have to be spent? What is the state gonna do to cover it? Well, hey, I don't have a great plan. I have heard that, different folks say, well, we'll come up with some money. We'll come up to help defense. Well, maybe we will. I don't know. I don't have the plan myself. But, and I don't know if that helps answer your question, Rhoda, but along the way, certainly the legislators that were already there have had ample time to be involved. And many of you folks have been involved at lots of the meetings, and I have. So there's some new ones, there's 30 or 40 new ones that may not that have had the chance, but it has certainly been in the headlines for this time period. So I don't know if that, in a lot of ways, and I've told a few guys who have come up and said, well, geez, there's so much here, I don't have time to understand it. And I said, wait a minute, you were here 2 years ago. You should have been into it. You knew it was coming back. So, I don't know if that answers it, but it's the best way. Throughout the process, Chaz held a meeting a couple of weeks ago on a Saturday. I went to it, and I heard the presentation from him and other folks. And I went through the material. He did put together a good packet. And I've had more doggone material on this than anything else.
I want to stop you here, Mike.
Yeah.
We were in on the first meeting. I got into this thing because of breaching of dams, because of the threat for the Snake River and the Columbia River Basin. Now, I heard from you fellows, Chaz has got it. Chaz has got it. It's going to be okay. I went to the first meeting of the compact, and Tweeten, who was talked first, came down with the hammer and said, you either go along with the tri-board or else you'll get sued. Montana, I've had a little stroke, so I have to control my voice a little bit. But or you folks are going to face all kinds of litigation. And of course, I've heard this business of well, it's going to be from both sides. But I'm going to tell you, here is something that I read in the paper, and it's raising its dirty head again after going to I don't know how many meetings and reading a lot of books, actually, and talking on the telephone and having a town meeting to alert people to the fact that this is not kids' play. It is not kids' play. It is forever. The revised, and this is what I read in the paper tonight. It didn't come out until this afternoon anyway. The revised compact would give the tribe water rights to the Kootenai River. The right shall remain suspended while the Libby Dam is still in place. Now, what in the hell does that mean? And pardon my French, but after all that's never going to happen, well, let me tell you, in Washington it's happened,
In Oregon, it's happened. In California, Northern California, it's happened, and I have friends in all of those places. Being a person whose husband was with the Forest Service. And you're not gonna kid me. This thing should not go further until we get some answers. And I don't care how long it takes, because this is forever.
Sure.
Okay, well, the answers are in the compact, and
No,
that's about
no.
all that I.
Answer her question about the
That's about all that I have to say. Basically, I came to the conclusion that I'd be a no vote, and it's similar to what this lady hears. I have some angst, and I've talked, Steve has his hand up here, I talked to him about it, that's what the repercussions are. But there comes a time for me when, that's what I said.
Thank you for your no vote.
Yeah.
Yeah.
And I also want to
Stick
say,
to
I
it.
thank Chaz for the work he's done, and I thank him for coming in and trying to, doing his best to explain it, so. I'm gonna sit down. Okay?